Let's talk the impact of this possibly going backwards to software, because one of the things that my initial thought when all of this happened, or when the leak broke, my first thought was the phraseology. Wait a minute, you can't un-OGL. And then I also was
I like
that's
that.
not something that
Un-OGL.
you can't un-OGL
That's
something.
great.
That's not something that can happen. Uh, but then, a lot of people were talking about the phraseology, or like, wait a minute, is there some magic word that was missing in the document? And then we got into whether or not legal terminology had changed over time, and whether, like, what phraseology might be used, and whether or not the GPL, which is the general public license, which goes back to software, had used particular language that maybe the OGL didn't, or when was that language used, and things like that. And Ryan Dancy was quite clear. There was like the idea of open licenses was not something that are generated with him, obviously, with this. It was based on all of this. So if something were to go down with the OGL here, and it's all of a sudden invalid, or could be revoked, or something weird about it like this happens, doesn't that have impact, like, to back propagate through, like, open license, or have impact on open licenses for software? Because I can just imagine, if, for instance, if this could be revoked or deauthorized or something like that, there must be some company out there who has some open source software that has been used, all of a sudden found its way because of being open sourced, on like everybody's computer in the world, and who would really like to all of a sudden claw that back, and all of a sudden be getting royalties on every computer in existence, or something like that. Does this have wider relevance in that whole world?
It's a good question. I mean, the reality is the open source software ecosystem and that entire kind of branch of licensing is really quite separate from the open game license and open content licenses more generally, right? So, and I'm referring there to things like some of the Creative Commons licenses. So what I mean by that is I don't know that there's a lot of cross-pollination other than at the very beginning, right? When Ryan Dancy like specifically cited open source software licenses as being the kind of inspiration for the OGL. But in the subsequent years, like I don't think there aren't a lot of people in the open source software licensing community who are looking at the open game license and Creative Commons licenses and saying, hey, how are those working? And vice versa, right? Like they're parallel streams of activity. But I mean, yes, you're absolutely right. Like, look, if you get a bad decision from a court which pertains to the open game license on something like revocation or authorization, yeah, absolutely. Like that could have consequences for open source software licensing because of the way that legal analysis works, right? Like the way that lawyers think about things and the way that they make arguments is by analogy and by applying, similar situations or the legal consequences in similar situations to each other. So certainly somebody who's, trying to enforce an open source software license, if we got a bad decision on revocation in the open game license space, could look at that decision and say, oh, well, this might apply to open source software licensing. So yeah, like the implications are broader than just the OGL. They extend out to open content copyright licenses generally, and then beyond that to open source software licenses.